All right, let's take you to this story now. There's some good news for South Africans who have moved abroad. The Supreme Court of Appeal has dismissed a High Court ruling stripping people of their citizenship. According to the SCA, legislation which led to the loss of South African citizenship for those acquiring citizenship of another country is irrational and unconstitutional. People normally need to ask the Minister of Home Affairs for permission to retain their citizenship. Let's discuss this further now with immigration lawyer Craig Smith. Mr. Smith, thank you very much for your time here on eNCA. Just firstly, do you think, as an expert, that the High Court erred in even not granting the DA's application for leave to appeal their judgment before they actually won to be able to go to the SCA?
Good afternoon. Thank you very much for having me. Well, if you look at this decision by the quota quo, which was then overturned by the SCA, effectively the quota quo took a position that said, in terms of the legislation, well, if you voluntarily decide to take up another nationality, you are effectively consenting to your forfeiture of your South African citizenship. And that they consider to be rational. In other words, it's a decision that they would say its means to an end is absolutely aligned. And the SCA obviously took a different view, and took a correct view, in my view, based on upholding the Constitution.
And I know, Mr. Smith, that you have clients that are in this predicament, and I think they'll celebrate this ruling. We'll try and break down exactly what the SCA said, because I know that the application had about 3 issues in Section 61A that the applicants wanted the law to find unlawful. But talk to me about the fact that this was an act that was created in apartheid to keep exiled freedom fighters from being able to come back here, and a democratic government that was part of that, keeping an act like that in the Constitution.
Well, this act came into play, it commenced on the 6th of October 1995. One must also appreciate that the way Home Affairs structured this was, well, if you left South Africa prior to the 6th of October 1995, you would have been considered to have left for, let's just say, activist reasons. And in that regard, they created an out for those South Africans abroad to be exempt from losing your South African citizenship. However, when they came along on the 6th of October and passed the legislation, it then had a cutoff date. So unfortunately, if you were abroad and you took up another nationality on or after the 6th of October, you were suddenly treated completely differently. And I think that's the issue. And that's where, the Constitution came into play. Remember, we're sitting with our final Constitution from 1996. So suddenly our Constitution provides this oversight role, which is so important for our rule of law and staying abreast of developments. And this is how our law evolves. So it really is a victory for the Constitution.
So it also ruled, the court also ruled that, on the 6th of October 1995, with the act having been brought in, all those people who were affected by the decision on the 6th of October 1995 have a right to then get their South African citizenship back. And we all know that could be thousands or even millions of people that need to apply for this. They used to have to ask the Home Affairs Minister to grant them this. How will this work now? Do they just automatically have a right, and they should come back and get an ID? How would this work?
That's a very good question. I mean, ordinarily, if you wanted to take another nationality, you'd have to get the permission of Home Affairs before taking up the nationality, and who knows how long that could take. If it's a dysfunctional Home Affairs, you can't get permission, and then it's stagnates, or it puts you in unfortunately a difficult position to get another citizenship. But obviously what we have now is you have a situation where Home Affairs, or the SCA, has now made a firm decision on the constitutionality, which means now which you raise would potentially be the floodgates. I think that's and the court discussed the aspect of retrospectivity. retrospectiveness of this decision, and they said, look, if you're going to make this decision effective, you've got to make it retrospective. So you're quite correct. There are so many people now who are abroad, and frankly, they may not even know about this decision. And part of the problem also is Home Affairs have been very slow in many instances, and in this particular situation, to inform the public of their rights or lack of rights or the consequences. So people don't even realize when they're abroad. They take another nationality. And in many cases, as in my business, South Africans want to come back for whatever reason. And they're South Africans after all. And here's the problem. So you may have lost your South African citizenship. You then take up another nationality, you have kids. The kids don't then get their right to citizenship, which they would have got by descent. And now you have this state of flux where what they are proposing is, in terms of Section 15 of the Citizenship Act, you can now apply for a certificate. But the difficulties of that is there's an interrelationship with the Identification Act. Those South Africans who are 16 or older must have an ID before you apply for a passport. If you're a South African, you're born abroad, you need to have a birth certificate. And the question is, how are Home Affairs going to organize themselves around this new piece of and constructive piece of law that is going to come into play, and how Home Affairs are going to equip themselves from a practical point of view in dealing with these myriad of large numbers of South Africans who rightfully have now succeeded in being recognized that their badge of identity as a citizen is being respected by our Constitution. How Home Affairs does that is the million-dollar question. It shouldn't be actually difficult. If they organize, the minister will probably have to draft some regulations as to how it's going to interface and assist and inform those South Africans who've been caught out by this in the most efficient way. And you'll obviously have to deal with the various South African missions abroad. Those many UK South Africans would obviously, and in the US, and Australia, and whatever, all those South Africans, who wish to return or wish to just continue staying where they are, but want to obviously rightfully have this exactly. And I think it's now a case of watching closely how Home Affairs reacts to this, insofar as protecting and obviously giving effect to this major victory for our Constitution. Otherwise, it comes to zero.
So, Mr. Smith, then the judgment by the Supreme Court of Appeal clearly will also affect some of the legislation around immigration then?
Well, it doesn't necessarily affect immigration. I can tell you what used to happen. If you did take up a foreign nationality, it would have an immediate impact if you had then started a family. They wouldn't have the right to go and get a South African passport and would literally have to get, for argument's sake, a British passport. Now you ask about the Immigration Act. If they then came to South Africa, they would come to South Africa, and here would be the difficult situation. And I've handled so many of these matters. The family returned to South Africa. The South African now is relegated from a South African citizen to literally, it is actually a permanent resident, but there's a process even behind that, even to return as a permanent resident. The kids, say the partner is Canadian, so the partner has the Canadian citizen, comes to South Africa. The kids, because because the partner took another nationality, the kids are now Canadian. So you have a whole Canadian family and an ex-South African. Yes, then they would have to go through, and would have had to have gone through, the Immigration Act afresh, as if they are being treated as foreigners. which now this law is saying they should never have been relegated. So the Immigration Act would have a place to play, and the question is, just like the other knock-on effects of other pieces of legislation need to all come together, and the law is in this instance largely dependent on the minister making suitable and apposite regulations to deal with this.
All right. Thank you so much, Mr. Smith, for speaking to us and unpacking this ruling by the Supreme Court of Appeal. That was immigration lawyer Craig Smith.